housed in St. Pete sometimes, will present something very interesting that happened yesterday. And Bob Welker will then take over after that. Steve Lang is going to report on a very interesting meeting that the Board of Trustees of St. Pete campus had yesterday. And a piece of the reason is that we reached out. Debbie Sinclair indicated that we'd better turn to our state organization with Marshall Ogletree as the executive director to begin trying to get some support for changes. I did that, and Steve now will tell you exactly what happened at a meeting yesterday that he attended. Go ahead, Steve.
Okay, we had a board meeting at St. Pete yesterday, which included some of the Board of Trustee members. And I'm not going to repeat everything that happened. There were school superintendents there who were against some of the reorganization, particularly of the College of Ed. The thing that interested me was that the Board of Trustee members who represented the USF Board of Trustees, who were there for the St. Pete meeting, appeared to be just as confused and unaware of some of the moves of the senior administration as everybody else. And I find it fascinating that this week, deans, chancellors, and even some Board of Trustee members were only notified of some of the changes and budget cuts maybe on October 14th and some on October 20th. And so it appears to me that there's an awful lot of surprises that did not involve the public, the administration, and even the BOT. So at that point, though, I'm going to turn this over to what we really want to know about, which is Bob Welker, our chief negotiator, and what the contract currently says about things like non-renewal, layoffs, and recall. So Bob Welker, it's your floor.
Well, I'm certainly happy to be here today. I'm the longest serving employee at the university. So you might think I've seen the good, bad, and the ugly, but I haven't seen anything yet. There's still a lot more to come. So what's happening right now is something that's just extraordinary. But the important thing is the collective bargaining agreement is negotiated between the UFF, United Faculty of Florida, and the administration. But we negotiate that agreement for all in-unit employees. But it's the union, which is the recognized representative of the employees, who do the negotiations. So the current collective bargaining agreement, I would like to go through, in particular, 4 articles that are very important. The first article is Article 1, Recognition 1.2, University Rules and Policies. It says no existing, new, or amended university rule, policy, or resolution shall apply to employees in the bargaining unit if it is inconsistent with or conflicts with an express term or provision of the agreement. It's extremely important because a lot of people are contacting us and saying, what about this regulation and that regulation? It says this, it says that. I don't care what it says. It does not apply to in-unit employees if it's inconsistent with or conflicts with an express term or provision of the agreement. Now, if Gray can move on to Article 8. Article 8 includes appointments. When you originally were hired, you had a letter of offer and it contained certain elements. There are 13 elements which the letter contained. And number 3 was employment unit, department, college, institute, area, center, etc. 9, % of full-time effort, FTE assigned. 10, salary rate. 13, principal place of employment. We are probably the only university in the state of Florida that has 8.4. we were very fortunate to negotiate this. I'm not sure the university really understood the import of this, and we didn't really understand how important it would be until now. We're probably the only university in the state in which the administration cannot institute across the board salary cuts and furloughs. They cannot do it at USF. The general counsel admitted, absolutely, we cannot do that. Now, why can't they do it? 8.4, changes in appointments and supplemental appointments. Within 30 calendar days of any proposed changes in appointment terms, listed in 8.3A, 1 through 13, an employee shall receive a written employment document from the university outlining the proposed changes. Now, next is the language that probably no one else has, but that we have. We have this language. No such proposed changes shall become effective and binding on the employee, except an increase in salary rate or promotion to a higher rank unless and until agreed to and accepted in writing by the employee, period. Therefore, they cannot do an across-the-board salary cut, FTE cut, or anything like that. However, they can come to an individual employee and say, would you be willing to take a salary cut? What they might say is, I'll tell you what we'll do. We'll reduce your FTE from 1 to 0.75. You won't have, a research assignment or a service assignment. Now, they can make that offer, but what you have to be extremely careful about in accepting any such offers like that is how could this affect your retirement, but more importantly, your health insurance. Your health insurance. Apparently, if you went from a 1.0 FTE to a 0.50 FTE on a family plan, you could be paying over $700 more a month, possibly, for the insurance. Right now, it's about $180. I think it goes up to like $940 or something if you only had a 0.50 FTE assignment. So if you're willing to take, and why might you take a furlough? Let's suppose you just got Social Security and you're thinking about retirement, and they come and say, I'll tell you what we'll do. We'll cut your FTE down to 0.50. We'll cut your salary in half, and you're getting Social Security. But that might be a good option for you, but you better realize you're also going to have to pay more for your health insurance. But anyhow, all I can say is then they can't do across the board salary cuts or furloughs, but they can come and negotiate with individual employees. Next is Article 12, non-reappointment. Now, the most important thing to say about non-reappointment, you cannot non-reappoint tenured faculty, period. 12.1 says, except as provided in Article 15.9. 15.9 is tenure. So non-reappointment cannot be applied to tenured faculty. However, it can be applied to anyone else, though. And we'll talk about that later in Article 13. Doesn't matter if you're here 5 years or less or more than 5 years. It does not matter. You're in that group that can be non-reappointed. The only group that can't be non-reappointed are tenured faculty. Now, what it says is notice. They have to give notice. And it says you're entitled to the following notice, which means they have to give it. And for people in the first 2 years of a continuous university service, they get the equivalent of 19.5 weeks or 1 semester notice. If you've been here for 2 or more years of continuous university service, you get 1 year notice. So basically, you're guaranteed, if you've been here for 2 years or less, you're guaranteed when they notify you, you have 1 semester. And if you've been here more than 2 years, you're guaranteed another 1 year of employment. Now, 1E, it talks about you can ask for the reasons why you receive non-reappointment. Of course, it's very clear that non-reappointment is not a disciplinary action. No reappointment shall be used as any form of disciplinary action. So you do have a right to ask for a written statement on the basis for the decision to non-reappoint. And probably what the decision is going to be is we don't have the money. Right now, that's probably going to be the reason they will give you for non-reappointing you. Now, is it grievable? The answer is yes, it is grievable under 12.3. So you can file a grievance because of an alleged violation of a specific term of the agreement or because of an alleged violation of the employee's constitutional rights. Now, what would be a possible alleged violation of a specific term of the agreement? Article 5 on academic freedom and Article 6 on discrimination. So if you think they picked you out, and you might be difficult to prove, but you could allege discrimination, and discrimination is Article 6.2, and it lists discrimination based on race, color, sex, gender identity and expression, sexual orientation, religion, national origin, age, military status, veteran status, disability, political affiliation, or marital status. Those are grounds that you could argue being non-reappointed because of one of those. The problem you get is someone said about the College of Education. Well, most of the people teaching undergraduate program are women. Well, maybe you would lay off people in engineering, and you might say, well, most of the people that are laid off were a certain nationality. Tell you the truth, I'm telling you ahead of time, I'm not sure that's going to fly. I'm just telling you that you say, well, we're laying off 50 people in the College of Education and 40 are women, and therefore I think there's gender discrimination. I think that would be an extremely difficult thing to prove. Also, academic freedom. Now, academic freedom is important to remember. Let me just read. Academic freedom is the freedom of an employee to discuss all relevant matters in the classroom, to explore our avenues of scholarship, research, and creative expression. Now, here's the next important one: to speak freely on all matters of university governance, and extra important, and to speak, write, or act as an individual, all without institutional discipline or restraint. So I'm saying that, yes, if you get non-reappointed, it is grievable, and probably the article on academic freedom, Article 5, and Article 6 on non-discrimination would be possibilities that you could allege that you were non-reappointed in violation of the collective bargaining agreement. Also, in 12.4, if the decision not to reappoint was based solely upon, there's a whole list of things here, but the first one is adverse financial circumstances. Then the university must make a reasonable effort to locate appropriate alternative or equivalent employment within the university. And if you don't have that employment for a period of 2 years, should an opportunity for reemployment arise, they're supposed to give you notice of that. So you might look, I'm not going to go into detail on those, but there are non-reappointment considerations. And I'm sure the reason they'll give you is adverse financial circumstances. But then there are certain rights that you do have about trying to find alternate employment. Now, the next, so therefore, the people that are tenured cannot be non-reappointed, but anyone else can be, and they can really pick and choose who that might be. There's nothing like we have in the layoff article, which I now will discuss, which does have certain protections for people other than tenured faculty. The same thing on the layoff unit on 13.1. In the result of adverse financial circumstances, et cetera, reorganization of academic, there's a whole list of things there. If they'll have to notify the union not in less than 30 days prior to taking the action, and we can consult with them. well, that's fine. We can talk. But I thought was interesting about what happened on consultation. The president of the university consulted with the union. The president consulted with the Senate. The president consulted with deans and other administrators, and then the president acted. So all I can say is, yes, I now can say I consulted with everybody, and this is what I did. And for all I know, that's what they were going to do anyhow. So they just went through, a charade of, consultation. But anyhow, the next thing is the most important thing, and I'm going to come back to this later, but this is the most important thing in Article 13.2, layoff considerations, the selection of the layoff unit. And that is probably the most important article. And I'm going to probably come back to discuss that in more detail after I go through some of the other things here. Layoff, if there's an affirmative action program, that will be taken into consideration. They would have to notify the union if there was an affirmative action program that affected their decision concerning layoffs. Also, 13.3, alternative equivalent employment, the university shall make a reasonable effort to assist the employee in locating appropriate alternative or equivalent employment for laid off employees within the university. Now, let me go back to 13.2. The selection of employees in the layoff unit to be laid off will be determined as follows. Now, this is different than from the non-reappointment article. This article says no tenured employee shall be laid off if there are employees who do not have tenure in the layoff unit. So basically, if you have 10 people in a layoff unit and 5 are tenured and they're going to lay off 3 people, it can't be any of those 5 tenured employees if you have people that aren't tenured. So tenured are the top round of those who are protected. Tenure are protected. Unless all the people in the layoff unit are tenured. So what if you have a program, you're going to lay off, you're going to close the program down, and you have the only people teaching in the program are tenured. They're all going to lose their job. So what's important is what is the layoff unit? And that's what I'll talk about. And that's probably the toughest thing. Then it says, no employee who does not have tenure in the layoff unit with more than 5 years continuous university service shall be laid off if there's any such employee with 5 years or less service. So now we have a second tier. The first tier of protected or tenured. The next tier protected is more than 5 years. Then the lowest tier of those protected are 5 years or less of university service. Now, let me go back then to 13.1b. That's the crucial provision, layoff unit. The layoff unit may be at an organizational level of the university, such as campus, division, college unit, school, department unit, area, program, or any other level of organization as a university deems appropriate. So there's no way for the union really to give anybody any counsel here and any advice about what are their chances about being laid off until we know what is the layoff unit. That's the crucial determination. What is the layoff unit before you know what your chances might be of being laid off? Now, to go on with the article, and this is kind of a little disturbing, I know it will be. Notice, employees should be informed. Doesn't say shall. An employee should be informed of layoff as soon as practicable and where circumstances permit. This is Weasley words. There's no question about it. That is not good wording. Unlike the non-reappointment article that basically says entitled to the following written notice On non-reappointment, the employees are entitled to the following written notice. On layoffs, it doesn't say that at all. It should be informed as soon as practicable and where circumstances permit. Employees with 3 or more years of continuous university service should, not shall, should be provided at least 1 year's notice. Those with less service with at least 6 months notice. So basically, I guess what they could do is the end of December, they could notify you and say, we're laying you off as of May the 15th or whatever. They could give you just 1 semester notice. Then employees who have received notice of layoff shall be afforded the recall rights granted in Article 13.3 above and 13.5 below. So there are recall rights for a period of 2 years following layoff, and employees pointed to, said you can read that. I'm not going to read it, but you do have certain recall rights. But again, the most important thing about the layoff article is 13.1b. What is the layoff unit? Now, the other things I'll mention them. I really don't want to, I guess, but I think I should mention them. We do have a Article 28 severability clause. It basically says, in the event that any provision of this agreement is rendered invalid by reason of subsequently enacted legislation, all right? That you don't have that on the screen. So what if the legislature passes some law and the law basically renders some provision of our agreement invalid? I could not get rid of that. They absolutely refused to take that out of Article 28. However, I did get something in there, which I think is extremely important. We got this 4 lines. This article is not intended to cede authority to any party to invalidate any provisions of this agreement. UFF does not concede to the constitutionality of any subsequently enacted legislation that invalidates a term of this agreement. The university or the UFF may choose, but neither is obligated to challenge said legislation. And I can guarantee you the union will challenge any legislation passed by the legislature that tries to change or invalidate any provision of this agreement. But that's the best we can negotiate at the time. They would not take out that particular provision, but I did get them, convinced them to add this last provision. So that's really about all that I can say about it. But all I would say is read the collective bargaining agreement. Those are your rights and responsibilities. And if you're a union member, we will represent you if there's any violation of the contract in reference to you.
Bob, is this time for discussion? People ask questions?
Oh, unfortunately, yes, Hartford. I'm sure everybody has a lot of questions, and we'll do the best we can answer. But again, the most important thing is, what is the layoff unit? Okay, yeah.